So the Theodore Weintraub, the Mark Hotel situation has had some updates. There was some updates over this lawsuit. This was the first lawsuit that Drake had been a part of, that Drake was attached to before his lawsuit after getting into a battle with Kendrick Lamar. Now, this lawsuit is a little bit different. It's a little bit strange. The Mark Hotel is a strange place. We'll keep it alleged. But the Mark Hotel has always been something that we've talked about on this channel. There's a lot of strange activity going on at this hotel. There's a lot of strange things that took place at this hotel. Ebony Prince was somebody that pointed out all of those things, and so was Theodore Weintraub. Now, mind you, Weintraub was somebody who wasn't really an innocent person, but he did get into an altercation revolving around Drake, allegedly. But in this case, he's known as VIP guest number 2, and his father is VIP guest number 1. So this is how it happened moving forward. We've talked about how Drake was staying at this hotel. It's been confirmed by Ebony Prince because this is where he obtained the items for Meet the Graham. We confirmed that it was Drake's items, but that's not the only thing that we've confirmed. There was other strange things taking place at this time where Drake had met up with a man in a wheelchair by the name of Christopher Alvarez. However, it wasn't as smooth as Christopher Alvarez tries to say. He waited exactly 4 hours from 12 a.m. to 4 a.m. for Drake to arrive at the hotel. And then once Drake arrived, he left 3 minutes or a few minutes after that. He didn't stay there with him for a long time, even though he waited in the hotel, risking other people's jobs in the process that Ebony Prince had talked about. But there was a lot of other strange things that happened as well. There was a FBI agent by the name of Gloria. There was a young teenager who was suffering from an injury. There wasn't too many details of the injury other than a liquid injury, which could have been some type of bleeding or whatever the case may be. But again, a lot of crazy stuff has happened at this hotel. Ebony Prince had pointed out himself, even saying that the FBI agent that was there when Drake was there was also named Gloria, which is the name on the album of GNX. There's a lot of things going on at this hotel. And Theodore Weintraub, the gentleman that got into an altercation with Drake, has been trying to get this discovery pushed. Now, a discovery is when two people who are going at it in court share information with each other, and he's been trying to get a discovery for a long time. There's even been a recent meeting in regards to this case, a virtual meeting that is, but this is the paperwork that's been submitted. And right here, they talk about getting the discovery from the Mark Hotel, releasing names that belong to the Mark Hotel during this time to expose the identity of the people that were there. In this case, it would be Drake and his father, as well as the mother and other people that were in Drake's entourage. So the document says, before the court is defendant Theodore Weintraub motion to compel plaintiff Mark, the Mark Hotel, to provide complete response to discovery request. Defendant asserts that plaintiff has failed to produce documents related to the alleged actions of defendant and plaintiff's claims damages. Additionally, defendant requests a disclosure of the names of all witnesses referenced to plaintiff's complaint, including the identities of VIP guest number 1 and VIP guest number 2, whose names have been mentioned but not disclosed. Plaintiff files a cross motion and seeking a protective order, including that the defendant sign a confidentiality agreement. Now, it is strange that they're submitting a protective order. They're probably trying to save their butt, trying to save some information or hide some information by using that. Now, why does Theodore Weintraub have to sign a confidentiality agreement? Why do they have to sign off before they exchange discoveries? Why are they requesting a protective order? Why is this hotel going so hard to protect Drake? Now, just to keep in mind what the Mark Hotel is, very strange. There is a lot of things going on at the Mark Hotel, but there's a lot of famous people at the Mark Hotel. It's not just Drake and his father. It's other people, not just the Grahams. We have people who meet up there before they go to the Met Gala. We've recently talked about Doechii being there. We talked about Pusha T being there, Pharrell being there. You can see Lady Gaga there. There's so many people that pull up there. It's just a place where people go before they go to the Met Gala. Real high fancy hotel. But that doesn't give it an excuse to have a confidentiality agreement about the guests that they have. If people already know who goes there publicly, if people are already taking photos of Drake and videos of Drake coming in and out of the hotel specifically for that day, then it doesn't make any sense why they need a confidentiality agreement, unless they don't want people to know what was going on when those people were there those days that could tie to something that happened, something either criminal or something that they just don't want people to know. In this action, plaintiff alleges that the defendant attempted to obtain alcohol at the plaintiff's hotel bar with false identification and engaged in disturbing behaviors in and around the establishment, including chanting and holding signs that the plaintiff's hotel denies, supports Epstein, and spreads diseases while accosting hotel guests and employees. In the complaint, the plaintiff asserts that the following causes of action: torturous interference with prospective business relations, libel, slander, and private nuisance. Defendant filed an answer with counterclaims asserting defamation, tortious interference with business, international infliction of emotional distress. The court issued an order dated October 3rd, 2024, granting plaintiff's motion to dismiss the defendant's counterclaims for failure to state a cause of action pursuant. In support of the instant motion, the defendant submits that plaintiff was served on October 27th with the following request: demand for witnesses. Now, I want to remind you that Theodore Weintraub is taking this very personal because the way that the Mark Hotel had wrote it in this lawsuit, they made it seem like Weintraub had gotten jumped for protesting amongst fans. They said that fans beat up Weintraub, when in reality, it was Drake's entourage. Allegedly, it was Drake's entourage instead. But from what it looks like online, there was no fans causing any harm to Weintraub. The only people that it looks like he got into a conflict with online were people in Drake's security team, entourage, or people that were with him. But again, the same thing that was happening around this time was Ebony Prince working there, him finding out these things about Drake, him obtaining the items from Drake that we later see him use throughout the day when it came to the jersey, when it came to him going to Popular Jewelry, which was also a receipt on Meet the Grams. This is where Drake had stayed at. And this is a place where Drake has been accused of doing something strange, at least for the very least that I could say. You have the security guard talking about how he has these reports, these incident reports, where he has FBI agents named Gloria responding to incidences occurring in a hotel room in regards to a young girl where a young girl is not supposed to be. And in the incident report, they're responding to a bodily injury, a liquid injury to the body. Y'all do the math on that one. Very strange. And in this time, Weintraub has been fighting to get the witnesses, fighting to get the people's name that go to this hotel. After plaintiff refused to fully and properly respond to Weintraub's discovery demands, Weintraub was left with no alternative but to seek the court's intervention. Weintraub filed a motion to compel plaintiff to provide the discovery and documents necessary for his defense. In response, the plaintiff filed a cross motion seeking to force Weintraub to enter a confidentiality agreement. Plaintiff's argument rely on board generalized claims about the court's discretion to regulate pretrial discovery and purported privacy interests, claims that are both baseless and unsupported by the facts in this case and law related thereto. The court erred and issued the order granting plaintiff's cross motion. Plaintiff bore the burden of demonstrating entitlement to a confidentiality. Plaintiff presented no evidence or credible argument suggesting any risk that Weintraub would misuse the information for purpose unrelated to this litigation. Further, there is absolutely no legitimate basis to compel secrecy for information that plaintiff must disclose in the normal course of discovery, especially since plaintiff has relied on the alleged confidential information, including the identities of VIP guest number 1 and VIP guest number 2, as a cornerstone of its claims in the lawsuit. Plaintiff knowingly invoked this information in its complaint and was fully aware it would be required to disclose it when it initiated this action. Plaintiff cannot now attempt to hide behind the guise of confidentiality to shield its own self-serving allegations. The order also ignores the plethora of other information sought by Weintraub that is not confidential. Requiring Weintraub to enter confidentiality agreement would unjustly burden and prejudice him. Such an agreement would expose Weintraub to a baseless allegation of breaching confidentiality while significantly impeding his ability to effectively use critical discovery for trial preparation and proceedings. For example, if Weintraub learns the identities of VIP guest number 1 and VIP guest number 2, which is Drake and his father, allegedly, he will naturally seek to subpoena and examine these individuals as part of his defense, both at deposition and trial. A confidentiality agreement would impose unnecessary procedural obstacles, creating undue costs and risk for Weintraub while offering no legitimate protection to plaintiff who initiated the lawsuit and placed the alleged confidential details directly at issue. Plaintiff has no legal or factual justification for its demand for a confidentiality agreement. Any risk plaintiff asserts are speculative at best and far outweighed by fundamental principles of fairness and transparency in litigation. Weintraub, on the other hand, has clear, undeniable right to obtain discovery and utilize fully and freely in defending himself against plaintiff's claims. It is just really strange how they're trying to protect Drake when the whole internet knows already that Drake was there. The items from the Mark Hotel belong to Drake. There's multiple pictures and videos of him coming out. I don't know why the Mark Hotel is so dead set on protecting Drake. They want to protect his name so much that they want Weintraub to sign a confidentiality agreement so that way he doesn't even bring their name up in court. Otherwise, he'll be liable or responsible and face consequences for doing that. They're trying to shut him up, but why are they trying to shut him up so hard? If the proof is already out there that Drake was there on those days when he was there and you could hear Weintraub in the background, there is no reason why you should be trying to do this unless there's activity going on around that time when Drake was there that you don't want people to know about. You don't want them to know about it so much you're willing to just try to keep him quiet by signing a confidentiality agreement. Accordingly, the court should grant Weintraub motion for re-argument, reverse its prior decision on plaintiff's cross motion, and denies plaintiff's improper and unjustified demand for a confidentiality agreement. Furthermore, the court should compel plaintiff to fully and immediately comply with all of Weintraub's discovery requests without hesitation or withholding. Anything less would deprive Weintraub of justice he is entitled to in this court. The argument, the court decision to grant plaintiff's cross motion fundamentally undermines the principles of openness, fairness, and equality that are essential to the judicial process. By requiring an overboard confidentiality agreement based on unsupported and conclusory allegations, the court has created an unjust and equitable advantage for plaintiff, leaving Weintraub at a significant procedural and substantive disadvantage. The references to other cases in regards to similar situations like this, the court properly granted re-argument upon at showing that it had overlooked or misapprehended the facts or law, or for some reason mistakenly arrived at its earlier decision. Re-argument is granted only upon showing that the court overlooked or misapprehended the facts or the law, or for some reason mistakenly arrived at its early decision. Here, the court misapplied the legal standards for discovery, improperly substantiated allegations, and ignored material facts and arguments raised by Weintraub. The court explicitly acknowledged that New York strongly encourages open and full disclosure as a matter of policy, and correctly noted as to CPLR 3101A mandates full disclosure of all matter, material, necessary in the prosecution of defense and action. Moreover, the court found that the information sought by Weintraub is both material and necessary, yet the court conclusion that the confidentiality agreement was warranted rests solely on plaintiff's baseless allegations of harassment and intimidation, allegations entirely unsupported by evidence in the record. Plaintiff has presented no evidence through affidavits, testimony, or otherwise that Weintraub engaged in alleged conduct. The court decision effectively assumes the truth of plaintiff's allegations in the complaint without affording Weintraub the basic due process, protections of discovery, a hearing, or trial. The premature presumption of liability is unjustifiable, fundamentally prejudiced Weintraub's ability to defend himself. Allegations alone cannot serve as the basis of curtail Weintraub's right to discovery, particularly when the information sought is material and necessary. The court's justification for the order that is necessary to protect the identities of non-party witnesses is deeply flawed. Plaintiff has failed to present any evidence that Weintraub has or would engage in any improper conduct toward the unidentified VIP guest number 1 and VIP guest number 2. These are purportedly high-profile individuals accustomed to public attention. Speculative concerns about potential harassment cannot justify sweeping restrictions on discovery. The reality is that it is far more likely that it is plaintiffs who seek to avoid public disclosure, fearing potential repercussions or scrutiny from these high-profile individuals. Moreover, withholding this information serves no particular purpose. The identities of these individuals will inevitably be disclosed. The current requirement for the confidentiality agreement merely delays the inevitable. while unfairly hindering Weintraub's ability to prepare his defense. This not only creates an unjust tactical advantage for plaintiff at Weintraub's expense, but also exposes Weintraub to baseless claims that he exposed the names once subpoenaed are issued, and many more people are made aware of the names through no fault of Weintraub. Even assuming some privacy concerns exist, the court's blanket order is improper. The court failed to hold a hearing to determine what, if any, information warrants confidentiality. Granting plaintiff unfettered discretion to deem information confidential is an abuse of discretion. The court must carefully balance any legitimate privacy interests against Weintraub right to material and necessary information. A narrowly tailored confidentiality agreement, if warranted at all, can only be issued after a proper evidentiary hearing. The court's order entirely ignores other discoveries sought by Weintraub and withheld by plaintiff, including financial records, booking information, and cancellation data, all of which are directly relevant to plaintiff's claimed damages and allegations. There is no basis for deeming such information confidential, and the court's failure to address these requests exacerbates the prejudice against Weintraub. Plaintiff cannot cherry pick what information to disclose while simultaneously using withheld information to support its claims. At the very least, the court should hold a hearing to determine the minimal and specific information, if any, the warrants confidentiality. A broad stroke confidentiality agreement without evidentiary support is an affront to fairness and transparency that deprives Weintraub of the justice he is entitled under the law. For the foregoing reasons, Weintraub respectfully requests that this court grant its motion in its entirety, as we all such other further relief as the court deems just and proper. So again, Weintraub is trying to defend himself. He can't seem to defend himself properly if they don't want to give him information, if they want him to sign a confidentiality. The lawyer is trying to argue that they're going to ruin the relationship between Drake and the Mark Hotel if they give up the fact that Drake was the one that was the VIP guest with his father. Like I said, I'm not sure why they're so worried about Drake's name being exposed if they could already see them on the internet. It doesn't make sense unless there's something else that they're trying to hide. I don't see how this affects their relationship if everybody already knew that Drake was there around this time. But when you want to take a look at data entry and people checking in and people checking out and cancellation data and all these types of things, I'm starting to think, what if they're just afraid to see some type of evidence that they're not supposed to see? What if they're afraid of showing them things that they don't want to show? Again, the whole argument that Weintraub is trying to make with this hotel is that they did him dirty. But the whole point that I'm trying to say, Weintraub is no saint, though. I just want to make that clear. I don't think that Weintraub is completely innocent in this. He was drinking there. He was drinking there with a fake ID. But that is questionable within itself, because when Theodore Weintraub got caught using a fake ID to drink there, the first thing that he said, and the first thing that his father said in an article, was that a lot of people do it. A lot of kids do it. A lot of kids go to the Mark Hotel and drink even though they're not of age. It was kind of like this open secret that people knew about the hotel. And once the fun got ruined for Weintraub, this is when he started doing his thing. But this is where he ran into Drake, and this is where these issues happen. But at the same time as this is going on, Ebony Prince is getting all this information, all of these items from Meet the Grams, finding out all these crazy things behind the scenes from the security. Also makes me feel like this is the reason why the Mark Hotel is trying to protect Drake and trying to make Weintraub sign a confidentiality agreement. They don't want him to speak on what has happened or what he could possibly find out through this lawsuit. We'll have to see what happens. I believe there's more updates following this. I'm just giving you a quick update now of what's happened so far, and we'll talk about it in the next video. But y'all tell me how you feel about this and get back to me, man. Big shout outs to everybody that shows love to the channel. Y'all tap it up for them. Everybody that you see on the screen, give it up for them, y'all. I appreciate everybody that's tapped in. Y'all tell me how you feel about this and get back to me, man. Like, comment, subscribe, and I'll see you on the next video, man. Peace. Keep it a legend.